So yes, within the discussion related to personal capacity, we have two more cases to be discussed. One is of that of minor. Okay, so who's a minor is essentially determined by the law of the land. So in India's case, we have our Indian Majority Act 1875. It says that, as you all know, that normal age of majority in India is 18 years. However, if a guardian is appointed, in such case, the age of majority becomes 20 years, 21 years of 21 years. However, there you will see that with respect to this, there is a difference between how age of majority is taken into consideration in case of criminal law and in case of civil laws, essentially in case of tort. So under criminal law, different gradations are made. So for example, someone below the age of 7 years cannot be at all held liable for any offense. Okay. And then you have the age of 7 to 12 years, okay, not liable unless he had attained sufficient maturity to judge the nature and consequence of his conduct on the occasion. So you have all these gradations made, okay. So and then that within in case of law of contract, minor's contract is considered as a void contract. So, but the same in case of tort, the law is little different than this. So, because as you know, unlike in case of crime, where there are punishments in case of tort, because it's a civil wrong, one has to pay compensation. So it's not as bad as it is in case of crime. Hence, within the law of torts, case of minor is dealt with differently than in case of that of crime. So what is minor's status when it comes to law of tort? Let's look at a minor, okay, the injury suffered by minor when he was not born, he or she was not born. So essentially prenatal injuries. So the problem is that when we talk about law of personality, we consider that one who is born, okay, one who is born alive, okay, until that person is dead, is considered as a person under the law. So law recognizes, that's the traditional understanding of law of personality, that your legal personality, your personality is recognized once you are born until you are dead, okay. But it's very much possible that you know that a child who's in the mother's womb, okay, who's not yet born, but in the mother's womb. And sometimes it is also possible that someone who has not yet been conceived, but the mother sustains some kind of injury or some kind of exposure, okay, because of which subsequently when the child is conceived, even in those cases, those incidences could have an effect on the child who is conceived subsequently. So what about those injuries which are sustained by a child, okay, in one case when he or she was in the mother's womb, and in another when she was not even conceived, but probably was conceived later on, okay, is conceived later on. So a child, okay, may claim damages, okay, sustained by her while she was in her mother's womb. So it's quite, recognized that while a child was in the mother's womb, okay, if she sustained any, damage, she can claim damage if she sustained any, damage while she was in the mother's womb, okay. But the thing is that the child has to be born alive, okay. If the child is not born alive, then there's no one to make that claim. So that is still, that requirement is still there, okay. However, the condition here is that the child has to be existing in the womb of the mother. So far, the idea is that the child has to be in the womb of the mother, okay. So the question arises that one who has not yet been conceived, can such an entity, when later on conceived, have such a right? We have to look into it. So what is the problem that the law faces here in this situation? The problem essentially is that the difficulty of determining when the fetus was alive and when it, died. Okay, and that's the question that leads to the, problem of imposing liability. So when the, child is in the mother's womb, what actually led, okay, or, caused the harm to the child. Okay, so that's something that is very difficult to determine, but you know that with the improvement in, medical technologies and all that, this thing has been overcome to a great extent and probably will be overcome to a great extent in future. And when a child, for example, dies in the mother's womb, okay, it's sometimes difficult for us to decide what really caused the death. Okay, but that's not the only issue though. Another jurisprudential issue that I just told you is that law in almost all common law legal systems recognize personality once someone is born. Okay, now one who is not even born, does law recognize personality in such case? Well, as I told you, the law is improving. Okay, so in today's time, in certain cases you see that law in fact recognizes personality if you suffered harm in the mother's womb and subsequently are born alive, or if you have been conceived, for example, because of mother's exposure to some dangerous gas or something. Okay, and subsequently when the mother conceives, the child also is born with certain disorders. Okay, so for example, in India you have the famous case of Union Carpet Corporation versus Union of India, in which case, okay, it was held likewise that children suffering from congenital disorders due to the toxic effects of the Bhopal gas leak are entitled to compensation. So you see that if something that had effect on the parents, okay, and led to certain congenital disorders in the child, okay, that also led to case of them being given compensation. So this with respect to this thing, there's a very important development that happened in England. Okay, under the British Act known as the Congenital Disability Civil Liability Act, 1976. Okay, this act is a very important development because it permits an action for injury to an unborn child in a certain case. Okay, so for example, if a child, okay, if a child can sue his mother if he suffered prenatal injury when his mother was pregnant. Okay, so for example, the mother, while she was pregnant, was driving the vehicle negligently, and because of that, for example, some accident happened and the child is born with certain deformities, then under this act, even the child for the damage that he or she has suffered can sue her mother for being negligent. Okay, now similarly, if the mother is, for example, pregnant and the father ill-treats her, okay, so for example, assaults her, okay, and that leads to some kind of harm or injury, so for that the child can even sue the father for such injury. Now, yeah, we have some certain cases. Okay, I don't think it's that important at this stage, but I will mention nonetheless. So one is Smith versus Brennan. Okay, where an action was brought by an infant plaintiff for injuries sustained while in the womb of his mother. Okay, resulting from an automobile collision due to defendant's negligence. The plaintiff, the child, was born 75 days after the incident with certain deformities. So what happened in this particular case? The trial court granted the defendant's motion to dismiss on the ground that it's a New Jersey case. Okay, so that New Jersey recognized no cause of action for prenatal injuries. So until then, okay, it was dismissed because New Jersey did not recognize any cause of action for prenatal injuries, because law recognizes personality only from the day that the child is born. So when the matter was taken on appeal to the Supreme Court of New Jersey, it reversed and remanded the matter to the trial. So, and held an infant has legally protected interest in beginning a life with a healthy body. Okay, so in such case it held that, okay, so let's recognize it like this. Okay, so once the child is born, let's recognize that child's right to be born, okay, with a healthy body. So likewise, okay, even though the child did not have personality when it was in mother's womb, but retrospectively it attributed certain kind of liability. So if another's wrongful conduct causes him to be born deformed, the infant may recover damages. Okay, so there are two theories, okay, as to how this was possible. One is that of question of fictive personality, that although unborn person is not recognized as having personality because it's not yet born, okay, alive, but by fiction we recognize its personality. But there is another theory that I just told you, is that a theory of recovery, that infant's right to begin a life with a sound mind and body. So, and in this in case, as you can see from the explanation given, okay, that it recognized infants, right to begin life with a sound mind and body. So whatever theory it is, so you see this case where the child could sue, for negligence leading to it being born with, certain, disabilities. So yes, similarly, we have many other cases like Re Baby, X 1980, Re Troy D 1989. So for example, ingestion of alcohol and illicit drugs as a form of, has been treated as a form of child treatment. Okay. Then there are also cases of, a wrongful life. Okay, that one ought not to have been born in a certain way, okay, but has been born in a certain way. So it's a case of, wrongful life. Okay, so one important case is Howard versus Letcher, okay, where the New York Appellate Division of the Supreme Court held that parents had no cause of action because it was the child who primarily suffered, and that it was not public policy of the state to weigh in the value of life itself. So the thing here is that the claim has to be made by the child. If the child does not even exist, then how can parents make that claim on behalf of the child? Okay. But in Park versus Chessin, another important case, okay, it held the state should recognize the action for wrongful life. Okay, so when one sustained a cause of, it's essentially sustained a cause of action against an obstetrician for allegedly failing to warn a couple with one child, okay, dead, of a certain, disease of the kidney, okay, that any subsequent child, okay, born would have 25% risk of the same disorder. So in this particular case, if the doctor had in fact informed the parents of the same, maybe they would have considered not having the child. Okay, because of doctor's failure, the child was born with the said, condition, and then subsequently died. So it was considered as a case of wrongful life. Okay. So yeah, so from this we can surmise, okay, from this entire discussion we can surmise that a child can sue even for, prenatal, injuries. Sometimes it even extends, okay, if you can prove that, when the mother is exposed to something that is dangerous, and subsequently when she conceives a baby, okay, and the baby, because of that exposure, is born with certain deformities, why not recognize that as a matter of right, and then accordingly provide, the child is provided compensation? That is definitely a development that we are witnessing. Now, what about the child, being sued? Can a child not be sued? So yes, but there is a difference that, that exists between criminal law and civil law. And what is that? It's simply this, that a minor enjoys no special protection in a suit filed against him for a tortuous act, like the way we see in criminal law. But a child's, okay, age will nonetheless be relevant, okay, when you attribute liability. Okay, it is very essential, so especially when, for example, a tort that involves, malice. Okay, so in such case you have to look at whether the child is capable of the same or not. Okay, so that is something definitely has to be kept in mind. Okay, so we have an important case by the name Tillander versus Gosilyn, okay, in which a child aged 3 years dragged another child of the same age for several feet, and caused extensive injuries, but as intention or negligence could not be imputed because the child is only of there of 3 years. So how can you impute any intention there? Okay, to him, because of his tender age, he was not held, liable. So you have to be able to impute, intention here, because or negligence. And how could you say that a 3-year-old, child is being negligent? Of course he is, but because he does not have the mental capacity of not being negligent. So yeah, so because of that, in this particular case, the child was held to have not been the child was not held as liable. Okay. Similarly, for example, a child, okay, imagine a child, okay, children are like playful, isn't it? So they play around with stuff, okay, need not intentionally need not intending to hurt anyone. So for example, two children are playing somewhere and one child throws something at the wall. It just bounces off of the wall and hits another child. Okay, in such case, would we impute intention to the child? Obviously we wouldn't. Okay, so in such case, law will not take the matter too harshly as against the child. So we have a case, okay, of the same nature by the name Hale versus Watson, in which a minor aged 12, okay, threw a metallic dart, okay, towards a post made of hard wood, hoping that a sharp end would stick, okay, but instead of sticking, the dart bounced and hit a girl standing close by. So obviously you wouldn't expect the child to know that that's a possibility, but maybe someone of our age will know that yes, if there's a child standing nearby, we ought not to throw stuff of that nature, which might just deflect and then hit someone and hurt someone. But you cannot expect that kind of maturity from a child. Okay. So in this particular case, the High Court of Australia absolved the minor of liability for negligence, as a boy of his age could not be expected to foresee the risk involved. Okay. Now imagine if the child had thrown the dart directly at the girl standing nearby, then obviously it is clear that the child did something with the intent to hurt. Okay. So in such case, obviously, the child would have been made liable. But remember one thing, that the protection is not of the same nature as is available under the criminal law. It's simply because of this that in criminal law the consequence is a little harsh, isn't it? So the child might be sent to juvenile homes. You do not want that. Okay, but in case of crime, that is not the case. Okay, you are made to pay compensation. So yeah, the liability standard is little different here in case of law of tort. So yes, this is essentially what the status is of the of a minor. One more thing that you guys need to know is liability of parent. Okay, in case of some wrong done by the child. Okay. Now the simple rule is this, that parents, okay, cannot be made liable for the wrong of their child, okay, of their children. Okay. But sometimes the wrong could essentially might essentially have been committed because of negligence on the part of, for example, the parents. So you have a young child and you let your child drive a car, okay, fast car, okay, and then the child causes accident. Okay, in such case, the fact that child has been able to get hold of the car and cause harm to others because of negligence on your part. Okay, so a father may be liable for his own personal negligence in allowing his child an opportunity of committing wrong, when as and when he supplies his child, for example, with a gun. Okay, you let your young child use a gun and then shoot. Okay, that's the wrong on the part of the father, of letting his son have the possession of a dangerous thing. Okay, so that's the case of negligence on the part of father. So in those cases, the parents will be held liable for the wrongs committed by their children, but not in other cases when the children are themselves held liable. So yes, that's the case of minor. Now we have one more, the case of insanity, okay, or lunacy. So insanity is a defense, okay, as you know, under the criminal law, okay, under section 84 of Indian Penal Code. It deals with act of a person of unsound mind, and it says that nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. So if you are incapable of knowing the nature of the act, okay, or that what you are doing is either wrong or contrary to law, then that could be a defense under the criminal law. But as you know, as we discussed a little while ago, that in case of tort, because there is no punishment but there is case of compensation, the same level of defense is not available. Okay, so it says insanity is a good defense in criminal law when at the time of commission of crime the accused, by reason of unsoundness of mind, is incapable of the nature of the incapable of knowing the nature of the act, or that what he is doing is either wrong or contrary to law. Okay, but this exemption, okay, is not available to this extent when it comes to a case of tort. Okay, for the simple reason that in case of tort, one has to pay compensation. Okay, now what is the nature of liability, okay, for insanity? So for example, if a tort, okay, if a tort requires that there is presence of specific intent and malice, okay, then obviously one can easily say that, okay, because of insanity, the said person is not capable of intending that specific intent, or capable of having malice. Okay, but if a tort does not require presence of any specific malice or intent, okay, in such case liability might be there. Okay, if you're, for example, if the defendant knew the nature of his act. So for example, the defendant here hit someone, okay, hit someone with the intention of causing some harm. Okay, so the defendant knows that my action will cause harm. Okay, but the defendant, due to his mental illness, did not know that it was wrong, or it was prohibited or against the law. Okay, in such case, even though the defendant did not know that it was wrong or prohibited by the law, but definitely did that action with the intention of harming. Okay, and because of that, the defendant here, despite unsoundness of mind, okay, might be held to be liable for such an action. Okay, but if it required, okay, so but if the wrong, okay, if the tort required any specific malice, so for example malicious prosecution, okay, deceit, etc., so in such case attribution of liability is difficult, because because of due to mental illness, we will assume that the court usually assumes that the said person is incapable of intending that having that malice or that specific intention. So that's essentially what the law relating to personal capacity is with respect to this insanity. So with that, we conclude our discussion on personal capacity when it comes to